Good afternoon, everyone. So on behalf of Stanford International Arbitration Association and CodeX, I would like to welcome you to our unique session put together by Stanford Law students, the Battle of the Robolawyers. So I'm Julia. I am a master student here at Stanford Law School together with Adrian, and we are the co-presidents of SIA. And today, first, we would like to thank CodeX for giving us the opportunity to co-organize a session here at the FutureLaw conference. And as law students, we are seeing AI transforming our future in our profession every day. AI is not just helping with research, but it's taking on tasks with thought that only humans would be able to handle. And today's debate would ask a crucial question: if by the end of 2026, will AI be better at deciding small commercial disputes than human arbitrators? This isn't just an academic question. It is also a very important topic for our careers after law school. So I would just like to introduce our speakers. As arbitrators, we have Hugh Carlson. He's the CEO of Three Crowns and a lecturer at Harvard Law School. Lawson, he's the head of product policy at OpenAI. Dr. Megan Ma, our associate director of CodeX. And as lawyers, on one side, we have Thor Alden. He's the innovation director at Deckard. Nader, he's the founder of Data Society Group. And opposing to them, we will have Omar Puertas. He's the partner at Quatro Casas and AI strategic advisor. We have also Robert Mahari. He's an MIT PhD student and a Harvard JD. And before we start, I would like to make a small disclaimer that the views expressed here by our speakers, they are their personal views, and they know that they don't correspond to their companies or affiliations. And with that, I would just hand over to Adrian, that he will explain our motion and how our session will work today. Thank you.
Thank you. So the motion will be, by the end of 2026, AI will be better placed to adjudicate small commercial disputes than experienced humans. One team is going to argue for pure AI arbitrations, another is going to argue for a hybrid, so human plus AI. Notice that there's no third option of pure humans adjudicating in 2026. I think one panelist from Europe joked that if this were taking place in Europe, there would be a third option of just human arbitrating. But as the famous arbitrator Toby Landau once said, and I'm paraphrasing, pitching about AI replacing lawyers to a room of lawyers is like pitching the merits of Thanksgiving to Turkey. And I think we're being deliberately provocative here and making sure we're looking very forward into the future, imagining a future without lawyers. So we're leaving the definition of adjudication, pure AI arbitration, hybrid, what this all means vague. It's up to the debaters to persuade you what this means. So we have a poll here. If we could all take our phones out to very quickly see what your gut instinct to this motion is, which side you're deciding, and then by the end, after the debates and the prompts by the esteemed judges, we'll have potentially a different result, and we're very excited to see what that would look like. So just take 30 seconds, please.
Yeah.
We'll continue to monitor this. Please take a photo if you want more time to decide. But otherwise, we'll leave the debate to our chair, Mr. Hugh Carlson.
Thanks very much. So we are delighted to be sitting here considering, instead of 20 years out, less than a tenth of that. By the end of 2026, and in the spirit of the US adversarial system, we'll be doing so through verbal combat. I will offer that the judges, over the course of the debate, will interrupt the debaters, and we may have some questions at the end as well. We want to keep them on their toes. And following the debate, time permitting, and we'll see how that shakes out, we may have some time for Q&A as well. Permit me, if I may, just to supplement one of the small points made by SIAA, which is that the views expressed here not only don't necessarily represent those of the employers of our distinguished debaters, but they may not even represent those of the debaters themselves. This is in the spirit of academic debate, and we want to give them liberty to express views that support their motion, or their side of the motion. So without further ado, I'm pleased to convene this debate and begin with the affirmative one last time. By the end of 2026, AI will be better placed to adjudicate small commercial disputes than experienced humans. John, take it away.
Thank you, Hugh. Thank you, Stanford. Fast plus cheap plus good enough is a win. Fast plus cheap plus good enough is a win. That's essentially the position of Team Robot. But before we dive in, I wanted to touch on a little bit of some ground rules for the debate. I presume, we didn't exactly talk about this beforehand, but extrajudicial comments by the debaters are obviously out of bounds. That wouldn't be fair. So I will not be proffering as evidence the esteemed and remarks and thought leadership by my fellow panelists. I won't be proffering into evidence that Omar, for example, in a very cogent, persuasive way, argued at the end of the last year that we face, quote, an inevitable progression toward a more AI-integrated legal profession, and that clients will naturally prefer faster AI-augmented services at potentially lower costs, not proffered into evidence, nor would I necessarily offer into evidence Robert Mahari's frontier research, which has allowed he and his cutting-edge team to, as he estimates, use our models to determine the outcome of lawsuits in the future. We might be tempted to think that that is AI adjudication, but Your Honor is not proffered into evidence. So now that we've settled some of the debating ground rules, what about the goalposts? What are we shooting for? What constitutes a win? I want everyone to keep their eye on the prize here, because you may be distracted or potentially tried to be distracted by my friends on the other side of the aisle with nitpicking, this is an imperfection, this is that. Good enough, okay? We only need to establish that robots compared to humans, that's your baseline, not compared to perfection, in small commercial disputes will be better placed by the end of 2026. So let's dive into that. Small commercial disputes. Make sure we're framing it. Don't let them move the goalposts. This is not criminal prosecution. No one's liberty is at stake here. No one's getting sent to jail. This is not even complex civil litigation. What are we talking about? A disputed $1,500 invoice for late marketing deliverables. A reimbursement claim against an airline for lost baggage. An eBay buyer who claims that an item listed as new arrived, used, and damaged. This is the caliber of dispute that goes addressed in some fashion, but too often goes unaddressed. And AI will empower us to do just that. Better placed. What might that mean? Not widely adopted, not replacing. Don't get too scared, all the other JDs in the room. Courts are not going anywhere. We have email, but we still have a USPS. We will very soon have AI adjudication, and we'll still have courts. We offer that better placed means more effective, but we will also show that besides being more effective, AI adjudication may be preferred not just by the disputants themselves, but by society, because it likely will bring about many important benefits. Why more effective and preferred potentially by the disputants? Basic formula probably jumps to mind. Cheaper, faster, I alluded to it, good enough. Lower transaction costs mean that more disputes that would otherwise by businesses be written off, would cause uncertainty if they chose to litigate it, or just suffered by individuals can be addressed. And you might ask me, how might it be implemented? It's one thing to just say it would be beneficial, but where's the there? A couple ideas jump to mind, and smart entrepreneurs will attack the market and fill the void. But right off the bat, you can write into your contract in mandatory arbitration that you would just adjudicate it via an AI arbitration method, so that you know that you're going to have a fast form of resolution. Already, I'm general counsel for Data Society. Like many companies, we prefer to have fee-shifting disputes or fee-shifting clauses, because we want to know that when we're the good actor, we don't even face the hurdle of the transaction costs of bringing up a lawsuit. We know that the other side will have to pay for it. AI, arbitration, or dispute resolution in any form adjudication offers the same solution. Likewise, you could have diversion programs for small claims courts. Think about it. You leverage the coercive power of the state. You have service of process on someone. They know they have to show up. But then you can intervene and let both of them avoid putting on the monkey suit, go stand in line early in the morning next to the people who are quibbling over their parking tickets, and instead settle it on the papers that you have to submit through the state's small claims system anyway. So it's tractable. The speed and cost benefits should be obvious to any of us, even if you're a law student, and anyone who's been in a courtroom or near it. Litigation, you're talking years and tens, if not hundreds of thousands of dollars. Arbitration is better, but it's months and many thousands of dollars. AI adjudication can be done in days and hundreds of dollars. It's a tremendous benefit. But it's not just a benefit for the disputant, it's a benefit for society too, in two important ways I want everyone to keep in mind.
John, before we get to society,
yeah.
Just a definitional point. How are you defining AI? Are you basing these views on AI as we presently understand it, or are you gazing into what you think generative AI will offer at the end of 2026? And if it's the former, what say you about hallucinations and how the market may react to those?
It's a great question. The technology that we anticipate, that we proffer for purposes of this debate, are those of, or is that of, late 2026. And if we want to anticipate what that might be, you could reverse engineer it, go back a year and 8 months instead of forward a year and 8 months, and remember that that version of ChatGPT, if you all were using it, was the one that everyone loved because it spun a Shakespearean sonnet using Al Capone's diction. Now, that was the headline at the time. It didn't have persistent memory. It was limited to from 8K to 32K in terms of context. Your input was text only. Obviously, we all know we use these things. We've come up upon a new frontier, and it's only accelerating. So it's the technology later. Thor and us later in the discussion will give you a side-by-side, but it's the future seeking AI. I do want to make sure I got the second point for the society benefit.
Quickly, we're a little bit over.
Yeah. The fact that you can reach more disputes means that those harms that would otherwise go unaddressed get resolved. That's access to justice. But there's also equitable justice. Everyone should read a paper recently out by Eric Posner, University of Chicago, and his research partner. He claimed that using ChatGPT as a judge was insufficient and worse than real judges and on par with law students because it was overly formalistic and didn't take into account sympathetic characteristics of the defendant. And we could debate about whether or not that's an important part of adjudication. But what we should all also recognize is that those soft factors, how sympathetic the defendant is, that's where bias and discrimination bleeds in. And by doing it with AI, you reduce, if not eliminate, that problem.
Thanks very much, John. Before we turn it over to the loyal opposition, any questions from either of our distinguished judges?
Trying to figure out if anything that you have said would not apply to AI as of today. Is it fair to say that you actually think that it's best placed, better placed even now?
No. I think that the delta between now and the tech of a year and a half from now is important. You'll see reductions in what everybody calls hallucinations, but perhaps most importantly, what technologists, and this may have been addressed even in earlier discussions today, think will be the biggest leap is in recursive reasoning, domain-specific abstraction, multi-day tasks. You can come back to the thing and pick up the arbitration or the adjudication where you left off a few days prior. That multimodal, stop and start, domain-specific expertise, that leap in reasoning, which is made possible by the context jumping from the 128 of today to forecasted for 1 million in the future, that level up is what gets you there.
Mike.
Perhaps I want to drill in on your definition of good enough. I know that earlier in the day we had mentioned about being able to crack the access to justice problem, and sometimes it's either no access or access that is what people say is good enough. How are you defining good enough in this case?
Good enough that in a small commercial dispute where you otherwise would face too high a transaction cost hurdle to clear, to potentially even access justice, you'd prefer to hit the play button, submit your documents on paper effectively, and get a resolution in days for hundreds of dollars instead of the alternative. That's good enough.
Thanks, John. Any further questions? All right, we'll turn it over to the opposition for an opening set of remarks, not to exceed 5 minutes.
Perfect. Thank you so much. In our view, the question of whether we should integrate AI into what is ultimately a sensitive and societally important process of arbitration and judging is probably the central question for this kind of group. The allure is clear, right? Promise of speed, efficiency, cost reduction, and it's powerful. But in our view, removing humans from the process entirely will ultimately erode trust in arbitral institutions and justice at large. Our position is really clear and fairly simple and shared by a majority of this room. A fully autonomous AI system for arbitration is unacceptable, both today and for the foreseeable future. What we advocate for is a hybrid model, one that strategically leverages the promise and abilities of AI while preserving the indispensable human element of judgment. Our argument has two levels to it. The first is that today's AI systems, and it seems like the other side agrees, are demonstrably not ready for automated arbitration. We have biases inherent in data. These systems struggle with complex contexts and nuance. They raise significant confidentiality concerns, and they lack sophisticated understanding of human emotions. Deploying fully automated systems today would not only be premature and risk unjust outcomes, it would also contravene emerging legal frameworks like the EU AI Act that treats all uses of AI in the administration of justice as high risk, and thus requires human oversight. Second, and much more fundamentally, even if we were to accept that there was some much more powerful, highly advanced AI system that overcomes all of today's technical hurdles, we maintain that a purely automated approach remains fundamentally flawed for reasons rooted in the rule of law, institutional trust, procedural fairness, which all demand continued human involvement. Let's dig into this a little bit more. Think about legitimacy and trust. Perceived fairness and acceptance of arbitral awards hinges in significant part on the human element. People want to trust the human being that is rendering the verdict, or at least know that somewhere in the background there is a human underpinning all of this. They need to be heard and feel that they're being heard, and we want to foster that kind of trust in arbitration. Second, normative authority and accountability. Arbitration often shapes commercial norms, even for these small kinds of disputes. And so the authority to create new rules when there's ambiguity in a dispute needs to rest ultimately in humans. And so the idea of delegating this authority entirely to AI, to let an AI fill in the gaps, act as a legislator, is completely unacceptable. There are also third, value judgments. We think that concepts like reasonable or good faith require nuanced understanding of the human condition, something that AI can only mimic statistically, but never fully grasp. Fourth, from pure resilience and safeguarding perspective, having some human oversight provides a vital check against unforeseen AI failures, biases, edge cases. And so just from a perspective of robustness and future-proofness, it seems prudent to have some human element remain in the process. And finally, on the topic of procedural choice and flexibility, a hybrid model just gives parties more options, right? We can leverage AI for efficiency. If good enough is good enough, then fine, they can go ahead. But they retain a meaningful ability to escalate things to a human, especially as cases become more complex or the stakes become higher. So the proposed hybrid model gives us the best of both worlds. We get to harness AI for data processing, speed, efficiency in the initial stages of debates and disputes, or for really simple cases. But we maintain that human adjudicators are embedded in the system for critical decision-making or appeals or oversight. So it's not about rejecting technology. It's about integrating it wisely. Ultimately, the goal in all of this technology for access to justice is not to maximize automation, it's to find optimal balances. A balance that delivers efficiency gains without sacrificing fairness, trustworthiness, and the essential human values that underlie justice. And so a hybrid model gives us this. A hybrid model gives us the best of both worlds and maintains much more safety and security. So I'll leave it there.
Thanks, Robert. Your loyal and learned friend opposite you placed some emphasis on the small nature of the claims. I think he may have provided us the example of eBay claims. Is that right? And you are placing a great deal of emphasis on trust. If we assume, and I've never filed a claim with eBay, but that the process of doing so would cost hundreds of dollars were it to be resolved by a human, and pennies on the dollar were it to be resolved by an algorithm, do you think that users would place so much value on the trust that would accompany a human being that they'd be willing to pay that premium?
So the point here isn't to keep a human in every single dispute. I don't think that a hybrid approach necessarily means that it's much more costly. It'll be marginally more costly. But the point is that somewhere at the end of the line, I know that I can get to a human if I need to, if there is a mistake. And it seems like this is a small price to pay in order to maintain trust. And I think trust matters even in those kinds of smaller disputes, right? You want people to use that feature, the kind of dispute resolution feature, whenever it makes sense, right? We want as many people kind of seeking out dispute resolution as possible to make sure that people engage in transactions, to make sure they use the platform and trust the platform itself. And I think having those human safeguards somewhere in the background really gives us the best of both worlds and maintains trust not just in the kind of arbitral process, but also in the platform and the commercial, whatever the thing that is giving rise to the disputes is in the first place.
So it sounds like you are affirming the motion, but saying that it would not be final, that final authority would have to sit with a human being. Is that right?
So I think one model of this, if we wanted to get kind of one level deeper about how we would structure something like this, is to say that you can appeal to a human. And you might want to have some sort of fee-shifting arrangement so that kind of the English rule, you can appeal, and if you win the appeal, then the other side will carry the costs, something like that, to kind of discourage frivolous appeals. And then parties can decide themselves, right? And I suspect that the majority will actually not appeal. The majority will take that verdict because it doesn't matter that much and they'll move on with their lives. But it's hard for us to sit here and say, well, $100 doesn't matter, it's a small dispute. For some people, it's really going to matter. And so just placing that safeguard in place seems to give us the best of both worlds. So that's what we're arguing for.
Just a clarifying question. If you're putting a great emphasis on trust and it's a preferred option for people, I'm curious, these models wouldn't necessarily only live in an adjudication. There would be alternatives where people could actually predict whether or not, if they go through an automated adjudication, they would win or not. I'm curious what type of role you think people's choices would be informed and how much premium they place on the trust in the normative side would be informed by the fact that they know that if they go to automated arbitration, it's likely 8 out of 10 that they're going to win. So motivated reasoning affecting and distorting their preferences.
So there seems to be, to me at least, there's a real fundamental difference between empowering kind of counsel and the legal advice of the parties individually and using AI to replace the judging. And we have higher kind of moral and ethical duties for judges than we do for lawyers, right? Even an appearance of impropriety is sufficient for a judge, whereas for lawyers we place a slightly lower, not a much lower, emphasis. And so if you had a tool that told someone, look, I've run the numbers and you have an 80% chance of winning or losing this appeal, I think it's less about trust in the institution in that tool. That's not what matters. That's just an informational kind of like helpful pointer, and then you can still make your own decisions. We don't care as much about trust in that kind of context. What we care about is that people trust the adjudicative process and they trust the platform on which they're transacting. And so I think that the two are linked, and it's interesting that they're linked, but they're really quite kind of fundamentally different.
I'm curious about your idea of the configuration of a hybrid. So one thing, it could be with the size of a small commercial dispute, it could be one arbitrator, and presumably that is a robo-arbitrator. But it could also be that it's a panel of maybe 3. And then if we have one robo-arbitrator and others are humans, is that necessarily a hybrid configuration, or is it the presence of a robo-arbitrator is sufficient for us to believe that that is machine arbitration, because one of the sort of inputs in there is entirely sort of end-to-end?
I think our perspective, and in a way, I think we have the easier side, because there are so many different configurations of hybrid, where you can have appeals to a human, you can have panels composed of a mix of humans and AI. all of those achieve the same end, which is to maintain some kind of human oversight in the system. And so we can think a lot about, and we can go into the details and brainstorm what the optimal kind of construction is, but fundamentally what we're arguing for is that there ought to be a human somewhere in the process. Yeah, but I don't think we're fundamentally opposed to the idea of a mixed panel, for example. Yeah.
Any other questions? Okay, thanks very much, Robert. We'll now turn back to the affirmative for a presentation not to exceed 7 minutes.
Thank you. So I want to talk about 5 things, a lot of which my colleague mentioned and I heard from the other side. So the first thing I want to talk about is society. So we heard Mr. Mahari say society really matters, and it matters how law is perceived within society. And as a member of society, I pay taxes. I think a lot of you pay taxes as well. We're all, most of us at least, are taxpayers. And if you look at the cost of commercial litigation on US taxpayers, it's about 2% of GDP, or $4,000 per household. That's a good chunk of money. And we heard the other side say $100 matters for some people. Well, it matters to me, and I hope it matters to a lot of you. If we don't allow some form of AI that is fully autonomous to come in and be able to judge these disputes, I think we're always going to be fighting a battle of making that number not go sufficiently low. And the biggest growth area in litigation of that number that I mentioned was in commercial disputes. A lot of reasons for that. You could focus on plaintiffs' firms, you could focus on litigation funders, but at the end of the day, bringing that number down is going to help us with city budgets, local budgets, and our own taxpayer budgets. So that's point number 1. Point number 2, Mr. Mahari mentioned the notion of something being fundamentally flawed. And if you look at how a judge were supposedly to use AI to assist in evaluating opinions from 2 sides. We had a question on an earlier panel about one side having hundreds of pages against the other side, and whether you use AI to interpret it, and whether AI is going to have an explosion of documents on both sides. Well, that's obviously going to happen, and the only way to deal with that is to have AI fully evaluate it and adjudicate it, because the skill set of a judge is fundamentally different than that of an AI expert. We can't expect judges to all of a sudden become AI experts overnight, and to be as good as AI as we need them to be fully effective. So what's fundamentally flawed is a judge who's been doing their job for many years, is good at what they do, all of a sudden having to use AI to enhance what they do, and we have to fully hand it over. It's like taking a taxi driver, putting them in a Formula One car and saying, good luck. That's effectively what we are doing here. And even if we wanted them to do that, some are going to pick up speed fast, some are going to crash, and we're going to have an uneven playing field of some judges learning faster than others. Okay, the third point. We heard about $100. I'm going to go back to that, right? I want to focus on the little guy. So if you look at the US business economy, 44% of jobs are from small businesses. 35 million small businesses in the United States. Now, the commercial liability is in the hundreds of billions. It's actually 347 billion. Now, nothing's going to make that go away overnight, but if you look at who bears that share proportionally, it's 7 times is what small businesses bear over the large businesses. If you look at what hits their bottom line, it's that litigation liability. And AI judges level the playing field. They allow those small businesses to grow even more, to hire more people, and to create more jobs. In effect, this is the same access to justice, or very similar, that we heard from Margaret Hagan earlier, right? It's the corporate version of that, where we're giving those small businesses a chance to really compete against the larger ones. The fourth point I'd like to make is talking about the human element. We heard from the other side that it's really important to keep a human element in the loop. Now, I'm going to disagree. There's this concept of judge shopping. So we all know what shopping is. We can shop for shoes, we can shop for clothes, we can shop for a lot of things. There's this thing called judge shopping, where if you've ever worked at a law firm, you'll know that you try to get the judge who is most favorable to your position. And there'll be a lot of effort put into it. There are vendors that help you pick what judge is going to be most favorable to you. In fact, this is so real that last year, the Judicial Conference of Courts, effectively the body looking at courts, they said we need to randomly assign judges. And they did this in 2024. They wouldn't have done that if they didn't perceive there being bias within judges, whether it's known or unknown. And that bias exists, and we're going to see even more bias on the small claims side. So we're only talking about small disputes here.
Thor, if I can interrupt on that.
Go for it.
So I may have misunderstood Robert's response to my question, but it sounded as if he was saying that the human being would serve, if they were to serve, in an appellate-like function, right? That doesn't strike me as presenting a great deal of risk with respect to judge shopping. It's that you would have this pressure release valve that an individual whom would be seeing maybe one in X number of cases, and it's not as if the parties to a $100 eBay dispute are going to be going out of their way to select the one that is most favorable to your case.
So I think that model introduces speed inefficiencies. I mean, the speed efficiencies we're talking about in an AI-based model, it could happen in minutes as opposed to days and weeks. Even if you have someone in the loop, they have to evaluate everything. If you have hundreds of pages of briefs, how do we know they're going to be making a good decision on what is ultimately could be a hard call? And I think we can only trust AI in those types of instances to evaluate hundreds of pages against hundreds of pages in an efficient manner without burdening that judge, the judge's time, and then ultimately taxpayer dollars in paying for that judge to oversee that.
If I could ask a question, you mentioned judge shopping. I'm curious what you think about model shopping. So what if the robo-arbitrator, there you have an understanding of the underlying, perhaps, personalities that these models present, and then you find one that necessarily is more favorable to the case. Is that not just a digital form of judge shopping?
So I think that's a fantastic question. I think ultimately if both parties agree to a model, I think that's not incongruous with what we're arguing here. We're saying that an AI can do it. Whether they want to pick one model over a different one is completely up to them. I've seen a lot of progression on the model side, and I want to point to a company, Vals.ai. They do a lot of benchmarking across legal categories, and we're seeing incredible improvement on those. But what we're also seeing is in a number of legal tasks, we see the tools outperforming humans. And whether it's Q&A or summarization, right, I think the models are going to get better, and you can ultimately pick the model you want, but ultimately we're going to see service levels that go above and beyond what humans can do today. And it's akin to what Danielle Benica said earlier, right? You want to add that new level of service, and it's the new level of service that the judge who is overworked and who doesn't have time, they have 30 cases a day, the AI can really evaluate it in depth every single time.
Curious, said you're speaking kind of to the little guy on behalf of the little guy, assuming that their position really is that the human is an appellate level. It seems like AI only, without an appeal, means that there's a higher chance that the bigger corporation wins more, and the only people that would ever really be appealing on these small claims would be the plaintiff, right? like the little guy. And so their model seems like it gets at the equity side, and it seems like your model gives the best chance for the corporations. Curious your reactions.
So I would argue under the appellate model, you would see what you're seeing today. So if you look at some of the Lexis reports and some of the surveys that are out there, most big law firms have AI. Most medium law firms don't. And if the smaller you get, the less they are likely to have AI. So what you are actually seeing today is the big law players, they have the better, fancier, more established AIs. And that's the model we're in today, where maybe we're not fully there with the person supervising at the end, but if you have a person supervising at the end, you have those inequities happening across law firms.
Thor, just a few more moments, and we'll have to turn it over to the opposition.
Great. Well, what I want to end with is a reference to a paper that came out last September from Google and DeepMind researchers. They came up with the concept of speculative RAG. Now, we all know what RAG is. It points you to the source. It grounds your truth. What they figured out was speculative RAG, where you have multiple submodels battling it out against each other as part of a more generalist model, that produces better results. They showed it produced 13% accuracy improvements. Now, what we're arguing is arguably no different from that. You have multiple models battling it out, and you can have an AI ultimately make the call. And we think long-term that's going to lead to a lot of really good results. And the research we're seeing really aligns with that approach that we propose. And I think the models, the speculative RAG, and some of the things we're seeing on the O and the O1 model align with having the AI ultimately make that call.
Thanks very much. Any additional questions from our tribunal? All right, to the opposition.
Very good. Let me see. So, interesting, huh? I would like to argue in rebuttal. First of all, we have heard judges, AI judges that are good enough. So what is good enough, right? Is 90% good enough? Is 99.9 good enough? If it's 99.9 good enough, you know, out of 1 million cases, you know how many wrong ones? 9,999. This is good enough, 99.9% good enough. So consistent injustice is not justice. Would you agree with me? So that is for good enough justice. Also, I was talking during lunch and yesterday for dinner with friends, and I mentioned, you know, so many times in what we do, litigators, is not what people say, it's what they don't say that matters, right? And they have not mentioned how AI actually makes a decision on the merits of the case, right? So what does it do? How does it reach a conclusion, AI? At the moment, we cannot even explain what it does, right? The machine itself, we know, that has the capacity to lie, to trace back what it does. It will tell you, I'm doing this, but it's doing something else, right? OpenAI released a paper a month ago telling us if you try to guardrail the machine too much, you actually pressure the machine to lie to you, telling you, I'm doing this, but in fact, I'm doing something else. So the conclusion for us, don't try to pressure too much the AI, right? So in effect, we have a level of uncertainty as how the machine is actually solving the issue, right? And that's why the human in the loop, be that at the beginning or as an appellate level as we have proposed, is absolutely necessary. Third, justice is not a transaction. You know, it's not a transaction for any of us. It's a relationship. The human being wants to be heard and wants to be treated as a human, is human dignity. It wants to understand that somebody has understood what they say, they care about it, and they show empathy as well, right? It is the human imperfection. It is the imperfections what make humans humans and not machines. And we're trying to solve a human problem through a machine that strives for 99.9% perfection. It is dignity, is the right and the hope of the human to participate in the resolution of a case that is important for him or for her. And that can never be served by AI automation. And finally, I would like to add, AI is extremely good at mimicking what we do. And there is immense value on that, don't get me wrong. I talk to friends about what happens when you can get 90% perfection with 0.001% cost. This is already happening. And that makes a lot of sense, and that has value on itself and by itself. But the fundamentally, the AI is just imitating what I do. It doesn't have true understanding of what happens, what it does. Not to mention it's not accountable for it. So again, when we are in justice, we are resolving issues that matter to human beings, we need true understanding, because only true understanding is what can make justice.
Thanks, Omar. We're going to go back to the eBay example from earlier. If I'm a buyer on eBay and my Beanie Babies don't arrive, I'm not sure that I care very much about whether or not the AI tool can reason its way through a decision in a manner that I follow. I think what probably matters to me more than that is the cost of that versus the alternative of the human decision maker, whose cost would, I think we can all agree, be a little bit more expensive, right? Perhaps a lot of it more expensive. And so it sounds to me like what you're saying is that there are certain flaws in the algorithmic decision making that would disqualify it from larger, bigger decisions, maybe criminal justice decisions, maybe bigger commercial claims. But is what you're saying, in your view, does it extend to these smaller commercial decisions?
Yeah, I think so, because fundamentally, first of all, where do we put the limit? Is $100? Is $10? Is $200? What is important? What does it make a difference? And to whom? And in which circumstances? We cannot tell. We cannot do, it's impossible to reach a conclusion on this, right? And second of all, at the very end, and in this case, clearly the hybrid model appellate, you can appeal to human if you don't agree with what AI has done, clearly has the advantage of, having the human touch, right? What is important for somebody, however costly. Because we're talking about cost, but not everything is cost when it comes to humans. Would you agree with me? So if it's more costly, but it provides justice in the very sense that a human being has understood what is going on, and it still says, you are wrong. But this is a human being like me who has heard me, who has empathy, who has understood, and then provides an answer. I think it is worthwhile.
I'm curious to kind of go back to this good enough in this marginal increase on ROI relative to your expenditure. Something that people care a lot about is who they mate. But why are matchmakers not more popular than dating apps? Relying on an algorithm where it's good enough, but you don't have to invest nearly as much. And it doesn't have the human touch. Just curious your reactions there.
On the matchmaking or in the... I haven't tried, so I don't know. I wouldn't know. So as I said, I think the good enough has immense value, economically speaking, right? But it doesn't justify not having a human finally making a final decision. Because it's not all about cost, right? It's not all about cost.
One thing I'm curious about is that you touched upon the point of mimicry, as well as a bit of that explainability. A lot of these models, if they're very good at mimicking, you can train them such that there are a robo-adjudicator that reflects some of the best in the world. And one thing that's interesting is that rainmakers don't always explain very well the way that they adjudicate necessarily. And the other element is that if your model reflects very closely to someone or is inspired by someone who could be an incredible adjudicator by most human standards, how then would there be an issue if you've created a machine adjudicator that reflects not only someone or people have widely described as a fair or wonderful or empathetic adjudicator, in addition to the fact that that adjudicator, as the person, could not really explain their exact process and how they arrived at certain...
Yeah, so if I understand correctly, what you're saying is, what if we could embed the reasoning process into the machine to adjudicate, like mimicking the best of the best? Is that what you're saying? Right. So essentially what AI is doing, right, even mimicking and having a reasoning framework, which I think is very interesting, is replicating the past. It goes into everything it has seen, and it comes out with a solution that has already happened. The AI, something happened here. The AI, if it were because of AI, we would never have had the French Revolution. Because AI replicates exactly everything it has happened in the past, and therefore we would not progress as a society. We would not change laws, but we change laws. And we change case law. And we change ourselves. And 10 years from now, you will think differently than you think today. And certainly when you have kids, you start thinking differently as well. But if, because of AI, we would never change, because there are just rules, and there is precedent, and everything is replicated into the future. That's not what you want, I think, and certainly not me as a society.
Thank you very much. Any additional questions? We'll turn it back over to the affirmative for a 3-minute rebuttal. John?
Thanks. I love this discussion, but I'm afraid we're getting lost in theory, and we're taking the perspective of a lawyer or a judge, and less the perspective of the individual, the claimant, the person who needs something solved, who might not care so much about justice with a capital J, or whether or not having a human judge is unacceptable in some abstract fashion. They just want a solution. So at the risk of getting too personal, this was not in my notes, I'll just give you an example of something that comes to mind. I used to live in LA, I'm renting a place, I break the lease and move out, and I recall getting charged, I think like $500, this is a little while ago, for my dog having scratched up the floors before we moved out. I remember I had the pictures. I was like, this is wear and tear. We addressed this in the lease ahead of time. Right was on my side. But I just started a new job at a boutique litigation practice, and I barely had time enough for my own interrogatories, much less even just assembling the basic overlay of an argument about why I was right and the landlord was wrong. If I'd known that I could sue the man and then have an off-ramp where I could just gather up the pictures and the lease and just dump it into a thing, and for $100, I don't care that it's maybe not perfect justice. I don't care that there's no human in a loop. Even if you told me it was a coin flip, that I was going to be right, I'm probably going to press the play button for $100, because what I get then is a solution or a resolution. And that's ultimately what a lot of people want. They don't have access to just settle this thing without the gatekeepers of the lawyers and the judges and all the esteemed things that we are, and which are valuable in certain circumstances, but don't let them shift the goalposts. For small commercial disputes, it's not necessary, and speed plus cheap plus good enough wins the day. And we've seen this movie before. All of these things will jump out to you. I think Josh made a great point when he talked about the dating services. A few other examples which are perhaps more parallel to legal adjudication. TurboTax, even LegalZoom style services. What was the initial objection? Not as reliable as professionals. Can't trust it. But what happened? Millions use them anyway. Millions of people use them anyway. They're probably turning them in this week, in the next 5 days. Access trumps perfection, and that's what AI adjudication gets you. Online therapy, AI mental health chatbots. We said robots can't do empathy, and yet increasingly people are using them. If you haven't tried it, they're actually very, very effective. And by the way, there are studies out there that show that even when we are fully aware that we're talking to a chatbot, when it interacts with us humans in an empathetic, human-centric way, we feel better. So if you have that overlay with AI adjudication, you're going to get results. Same thing with automated resume screening. I'll leave you with one just thing that I find very tantalizing. Josh touched on it earlier, and that is that with AI adjudication, this isn't really necessary for the debate, but I find this really interesting. If we zoom out, if we think about the future and how, as unsettling as it may be, what the future of AI adjudication looks like, it allows us to go from precedent, relying on judges' reasoned arguments, connecting the dots from one to the next, never mind how good you think they do that, how reliably and without bias, but it allows us to go to prediction and maybe even live guidance. We've set up this whole legal system, from the Code of Hammurabi millennia ago to the Magna Carta and English common law, because we as humans needed to be able to say to one another, what's the law? We're going to put it on a stone tablet, and then to fill in the gaps, we're going to rely on a judge to write it down, and even if we lay people can't go and figure that out, we have an attorney guild, lawyers, who can interpret it for us and carry that knowledge back to us. What AI adjudication gets you is the ability to have in your pocket an estimate of what is my position, what's my likely outcome of the case right now, or where is the line? If I'm that marketer who's disputing a late invoice and I turned in my marketing deliverables late, I could say, how late can I be before I lose this case? How sufficient is it? How much could I potentially recover if I half-ass it? If I throw it over the fence without it being perfect? That's a revolution in how we govern our behavior as a society, and it's only made available if we permit ourselves the efficiency, the speed, the lack of cost, and the good enough, which wins the day of AI adjudication.
John, I want to riff off of a question that Josh asked before, and Thor somewhat answered it, but I'd be interested in your views as well. Some of your examples are in B2C contracts.
Yeah.
B2C contracts will be drafted by the business. They are repeat players. They will understand these tools in a way that the consumer simply won't. What's to stop in these adhesion contracts businesses from selecting LLMs that are frankly going to see their way most of the time in a balanced and ultimately counterproductive fashion?
Yeah, the beauty of AI adjudication is that this is a knowable thing, traceable, metricizable, in a way that, whether you call it forum shopping or capture of repeat customers within B2C arbitration now, it's behind a veil. So the consumer doesn't appreciate how much behind the 8 ball they are when they enter into that contract of adhesion. If you're in an AI adjudication landscape, that's quantifiable out of the gate.
Assuming it's not confidential.
It needn't be.
Okay. And finally, rebuttal remarks from the opposition. Robert?
Thank you. So fundamentally, our opponents are arguing for full automation, and they give us two main arguments for this: cost savings and some sort of supposed neutrality. I think they overlook critical flaws and underestimate the kind of having our cake and eating it too appeal of a hybrid approach. Talking about cost, the hybrid model already delivers massive cost savings, right? We're not saying that humans are going to be involved in every single dispute, merely that humans are going to be available somewhere along the value chain to make sure that there is trust and some sort of recourse to a human. Full automation is chasing illusory gains because it is much, much harder to build a fully automated system than a support system. The amount of red teaming and error checking and evaluation you would have to do if you wanted to really fully automate this is so much larger than if we were just building some sort of support system, something that augments judges, and knowing clearly that at the end of the day, even if that system gets it wrong, there is a safety net. Ultimately, trust and legitimacy themselves also have tangible economic value. And so the fully computational approach fully ignores that. The opponents are also saying that AI is somehow more neutral than human judges, but it's not like inherently more neutral. It's learning from training data. It has the ability to amplify the biases that are in that training data, and it is more opaque and harder to detect challenges in AI reasoning than it is in human reasoning. Fairness requires trust and legitimacy alongside affordability, and the hybrid model provides us with exactly that. We're not arguing about whether or not there should be technology, we're just arguing about the proper role of technology. And it's not just about being cautious here, it's about finding kind of the optimal balanced path forward, harnessing technology in a way that increases efficiency without fully undermining or risking to undermine trust in processes. And at the end of the day, right, we started this by talking about 2026. And so maybe we're wrong. Maybe it turns out that people actually trust AI. AI models have gone beyond just mimicking human empathy, but really somehow embracing it. We don't think they will. But we can revisit this. And so it's unclear to us why we should take this very risky step now rather than taking a more cautious and more balanced approach. Thanks.
Any questions from Okay, well, that concludes our debate. Thanks very much to our advocates and indeed to our judges for their questions. I will turn it back over to our student representatives from SIA.
Thank you, everyone. So now we are doing a second poll, and you can vote one more time, and then we see the results.
Convince some of you.
Somebody's voting twice. Is that you?
We challenge the vote.
Just by way of preliminary results, I think the initial round, 2/3 of people voted for no, not to influence anyone who's still voting. Seems like there's a slight increase in people who are voting, or at least amenable to the yes side. I think one thing that we, the panelists, when we were discussing this, was having an AI, using OpenAI's platform to judge this debate as well. We had some fun tweaking around it. The preliminary results are quite hazy in the sense that maybe the data, we had different approaches to it. But I think this is a brief taste of how maybe AI can work with humans, not just in 2026, but for us as students, what we can look forward to in the future. And please join me again in thanking all these absolutely brilliant and fantastic speakers.